The benefits of a highly detailed, comprehensive power of attorney are numerous. Unfortunately, many powers of attorney are more general in nature and can actually cause more problems than they solve, especially for our senior population. Hi, I'm Antoinette Bone, estate planning, probate, guardianship, and elder law attorney in the Dallas-Fort Worth Metroplex. And today I'm going to highlight the benefits of a comprehensive, detailed power of attorney, including some of the provisions that should be included. A proper starting point is to emphasize that the proper use of a power of attorney as an estate planning and elder law document depends on the reliability and honesty of the appointed agent. The agent under a power of attorney has traditionally been called an attorney in fact, or sometimes just attorney. However, confusion over these terms has led to a change in terminology. Recent state statutes tend to use the label agent for the person receiving power by the document. The law of agency governs the agent under a power of attorney. The law of agency is a body of statutes and common law court decisions built up over centuries that dictate how and to what degree an agent is authorized to act on behalf of the principal. In other words, the individual who has appointed the agent to represent him or her. Powers of attorney are a species of agency-creating document. Now, in most states, powers of attorney can be, and most often are, unilateral contracts. That is, they are signed only by the principal, but accepted by the agent by the act of performance. Much has been written about financial exploitation of individuals, particularly seniors and other vulnerable people, by people who take advantage of them through undue influence, hidden transactions, identity theft, and the like. Even though exploitation risks exist, there are great benefits to one individual, that being the principal, privately empowering another person, the agent, to act on the principal's behalf to perform certain financial functions. In some states, a comprehensive power of attorney may include a grant of power for the agent to represent and advocate for the principal in regard to healthcare decisions. Such healthcare powers are more commonly addressed in a separate medical power of attorney, which may be a distinct document or in some states combined with other health topics in an advanced care directive. A separate document is required in Texas. Another important preliminary consideration about powers of attorney is durability. You should watch my video in which I discuss durable versus non-durable powers of attorney. Now, powers of attorney are voluntary delegations of authority by the principal to the agent. The principal has not given up his or her own power to do these same functions, but has granted legal authority to the agent to perform various tasks on the principal's behalf. All states have adopted a durability statute that allows principals to include in their powers of attorney a simple declaration that no power granted by the principal in this document will become invalid upon the subsequent mental incapacity of the principal. The result is a durable power of attorney, a document that continues to be valid until a stated termination date or event or the principal dies. Now, absent durability provisions, the power of attorney terminates upon the principal's death or incapacity. Here's the down and dirty, top 10 plus 1 benefits of having a comprehensive, durable power of attorney. Number 1, it provides the ability to choose who will make decisions for you rather than a court. Now, if someone is signed a power of attorney and later becomes incapacitated and unable to make decisions, the agent named can step into the shoes of the incapacitated person and make important financial decisions. Without a power of attorney, a guardianship may need to be established and can be very expensive. Number 2, it can avoid the necessity of a guardianship. Someone who does not have a comprehensive power of attorney at the time they become incapacitated would have no alternative than to have someone else petition the court to appoint a guardian for them. The court will choose who is appointed to manage the financial and/or health affairs of the incapacitated person, and the court will continue to monitor the situation as long as the incapacitated person is alive. While not only a costly process, another detriment is the fact that the incapacitated person has no input on who will be appointed to serve unless they have also created a pre-need declaration of guardian, which is possible here in the state of Texas. A well-drafted power of attorney can totally avoid the need for a guardianship, or at least kick that can down the road. Even if you have a power of attorney, it is still a good idea to also do the pre-need designation of guardian, just in case. Number 3, it provides family members a good opportunity to discuss wishes and desires. There is much thought and consideration that goes into the creation of a comprehensive power of attorney. One of the most important decisions is who will serve as the agent. When a parent or loved one makes the decision to sign a power of attorney, it's a good opportunity for the parent to discuss wishes and expectations with the family, and in particular the person named as the agent in the power of attorney. I want to recommend that you watch my other video on selecting a fiduciary to address issues that you should be giving thought to in terms of selecting who should be the agent. Number 4, the more comprehensive the power of attorney, the better. As people age, their needs change, and their power of attorney should reflect that. Seniors have concerns about long-term care, applying for government benefits to pay for care, as well as choosing the proper care providers. Without allowing the agent to perform these tasks and more, precious time and money may be wasted. Number 5, it prevents questions about a principal's intent. Many of us have read about court battles over a person's intent once that person has become incapacitated. A well-drafted power of attorney, along with health care directives, can eliminate the need for family members to argue or disagree over the loved one's wishes. Once written down, this document is excellent evidence of the intent and can be difficult to dispute. Number 6, prevents delays in asset protection planning. A comprehensive power of attorney should include all the powers required to do effective asset protection planning. If the power of attorney does not include a specific power, it can greatly dampen the agent's ability to complete the planning and could result in thousands of dollars lost. What I normally see is a statutory form. It is short and has a list of powers you are giving your agent that are defined in the Estates Code. This may or may not be sufficient for your needs. For many elders with health issues, the statutory form is unlikely to cover the situations that require asset protection planning. While some powers of attorney seem long, it is necessary to include all of the powers necessary to carry out proper planning. There's a reason a well-drafted power of attorney is long. It's not just so the attorney can charge you more money. Number 7, it protects the agent from claims of financial abuse. Comprehensive powers of attorney often allow the agent to make substantial gifts to self or others in order to carry out asset protection planning objectives. Without the power of attorney authorizing this, the agent, who's often a family member, could be at risk for financial abuse allegations. If asset protection planning becomes necessary, having provisions in the power of attorney that allow for gifting and self-dealing will be critical. Number 8, it allows agents to talk to other agencies. An agent under a power of attorney is often in the position of trying to reconcile bank charges, make arrangements for health care, engage professionals for services to be provided to the principal, and much more. Without a comprehensive power of attorney giving authority to the agent, many companies will refuse to disclose any information or provide services to the incapacitated person. Now, this can result in a great deal of frustration on the part of the family, as well as lost time and money. Number 9, it allows an agent to perform planning and transactions to make the principal eligible for public benefits. One could argue that transferring assets from the principal to others in order to make the principal eligible for public benefits like Medicaid and or non-service connected Veterans Administration benefits is not in the best interest of the principal, but rather in the best interest of the transferees. In fact, one reason that a comprehensive durable power of attorney is essential in elder law is that a judge may not be willing to authorize a guardian to protect assets for others while enhancing the ward or protected person's eligibility for public benefits. However, that may have been the wish of the incapacitated person, and one that would remain unfulfilled if a power of attorney were not in place. Number 10. It provides immediate access to critical assets. A well-drafted power of attorney includes provisions that allow the agent to access critical assets, such as the principal's digital assets or safety deposit box, to continue to pay bills, access funds, etc. in a timely manner. Absent these provisions, court approval will be required before anyone can access these assets. Digital assets are also important because older powers of attorney did not address digital assets, yet more and more individuals have digital accounts. And finally, a bonus, number 11. A comprehensive power of attorney provides peace of mind for everyone involved. Taking the time to get a customized power of attorney lessens the burden on family members who would otherwise have to go to court to get authority to perform basic tasks like writing a check or arranging for home health services. Knowing this has been taken care of in advance is of great comfort to families and loved ones. This document is incredibly powerful. Careful thought and planning needs to go into getting one drafted. While a bare bones document is probably going to be better than nothing, the best thing to do is to seek advice and counsel of an attorney who will explore with you your situation and craft a power of attorney that meets your needs. So, while the internet is cheap and easy, it is not likely to put you in the position you need to be in if your situation is complex. Now, this discussion of the reasons why everyone needs a comprehensive power of attorney could be expanded. Which benefits are most important depends on the situation of the principal and their loved ones. This is why a comprehensive power of attorney is so essential. Nobody can predict exactly which powers will be needed in the future. The planning goal is to have a power of attorney in place that empowers a succession of trustworthy agents to do whatever needs to be done in the future. I'm Antoinette Bone, estate planning, probate, guardianship, and elder law attorney in the Dallas-Fort Worth Metroplex. If you found this content useful and would like to see more like it, please subscribe to my page, like this video, and don't forget to tell your family and friends. Thanks for watching, and I will see you next time.